What happens at a weapons surrender hearing in Washington State? Are you in that situation? Do you know somebody is, or are you just interested in this area of the law? If any of that applies to you, this is the video for you, so stay tuned. My name is Lance Fryrear, and I'm a defense attorney located in Linwood, Washington. My law firm's been defending people charged with crimes for more than 20 years. And lately, we've been having a lot of hearings about surrendering weapons. And I've been putting out these videos to educate the public. And so if you find this useful, please like and please subscribe. More people will get the information they need. So let's just jump right into it. What is a weapons surrender hearing? And that's a pretty broad term. And so the primary one I'm going to talk about here today is if you've been ordered to turn in your weapons because of a temporary restraining order being issued against you. More and more, when a court issues a restraining order against you, and they're technically called protection orders in this state, but most people think about it as a restraining order. When a court issues a restraining order against you, more often than not, the court is going to order the person restrained, the respondent, to turn in any weapons that they possess. And sometimes the police have already taken your weapons when they serve you with the order. And so typically there's a hearing set later, separate from whether or not an order will be issued in the long run, a separate weapons surrender hearing to determine whether or not you've complied with that order that the police served on you. So there's that type of weapons surrender hearing. There's some other ones. If you got arrested and charged with an actual crime, typically a domestic violence crime, or in some case a felony, the court may also set a hearing to determine whether or not you possess any firearms. And so, believe it or not, in our experience, the criminal hearings are taken a little bit less dramatically and less seriously, less detail required in the criminal hearings than in the civil hearings, which doesn't make a lot of sense, but that's what we're experiencing here at the first part of 2022. So let's take the first situation. You got served with an order, and either the police took your guns, or you don't have any guns, or there's some guns you need to turn in. So at the weapons surrender hearing, the court is going to be looking for paperwork that you've filed. You need to file some paperwork prior to the hearing. And nowadays, typically the hearings are by Zoom, sometimes they're in person, so make sure you pay attention and look at your paperwork. If you're not sure, make sure to contact an attorney, okay? But if you didn't have any guns, you've never had guns, well, then you need to turn in something called a declaration of non-surrender. When I say turn in, that means file with the court with the proper cause number. You've got to sign it, you've got to date it, and hopefully you have that paperwork from when the officer served you with the instruction to turn in your weapons with this, hearing date. And if not, you're going to need to contact an attorney, or you can look on the court's website. But if you've never had a weapon, you're going to need to fill out the declaration of non-surrender, file it with the court, and then we're going to get to what happens in the court here in a second. Now, if you do have weapons that the officers haven't taken, you're going to need to typically turn those into the police department and make sure they sign some paperwork showing, what weapons you turned in and who took them and who has possession of them. And usually the law enforcement will have those forms available. They're going to need to know your case number and stuff like that. And what really should happen is you should have those forms already served to you when you got served with the hearing notice. So, don't go walking into the police station waving a gun around. Basically, I've seen in some of the situations we've dealt with where the client will keep the vehicle unloaded in their trunk and then show up at the police department and say, I've got this to turn in. Do you want to come out and get it? Just for safety of everybody. Again, though, you're going to need to take that paper showing what firearms have been surrendered. You're going to need to file that with the court prior to the hearing. Now, another weird thing can happen is sometimes, the officers are instructed when they serve you, they're going to want to take all the weapons you have right then. And in that case, they should give you a receipt. They should give you that paperwork. And most people assume that the police file that with the court themselves. And while that makes sense to assume it, I don't trust that, right? And what we do for our clients is we're going to make sure the paperwork that we were given showing what was seized, we're going to file that ourselves to be safe, because the burden on proof at these hearings is actually on us. It's actually on the respondent to show that they don't possess any firearms. And again, this is hopefully a temporary thing. Hopefully you can be successful at the hearing and the restriction will be lifted. It's not a permanent loss of rights. It's sort of a precaution that's in the law. And so we want to make sure we follow the law so we can have the best chance of getting our firearms back. So at the hearing, what happens is in some courts, the court will just review the paperwork, and if it looks in order, they'll say, okay, good enough, right? And in some other courts, and we've had problems with King County Superior, where they're going to really go over everything with a fine-tooth comb. And believe it or not, oftentimes a prosecutor will show up as a friend of the court at the civil hearing, right? And so they might have filed some documents, which you should be given a copy of, showing, what firearms that they show you've ever purchased. And then you might have to explain where these guns are that weren't turned in. And then that's when we need to be careful, because sometimes we didn't follow the law exactly, and we might be admitting to things that could be criminal. So you definitely want an attorney at these hearings, if you could have one, because they're not as informal as you would expect. At the hearing, if the commissioner or judge is satisfied that you've met your burden, that everything's in order, then they'll say, good, you're in compliance and you're done. Oftentimes, they might not be satisfied, and then they'll set another hearing, call you out of compliance, and then make you come back and provide more information. And you might ask yourself, well, what can happen if I just am never in compliance? Well, lots of things can happen. What comes to my mind from dealing with these hearings is, a contempt motion could be brought because it's a civil matter. In contempt, you could be fined, you can be put in jail for contempt. So it's important, even though this could be very upsetting that the government's trying to do this. It's important that you have help, have an attorney that can, try to protect you from yourself, make your best argument out there, and don't make the situation worse, because, the court has a lot of power. So at that weapons surrender hearing, you might be asked to testify about where certain guns are, or the petitioner claims you have guns and you never have. It's really a strange feeling to be in this way where you're trying to prove a negative, because how do you prove a negative, right? It's very difficult, it's very frustrating, and you're going to get through it, but there's a lot of landmines to avoid. So I want you to be really careful. Let's then move on to the other situation, criminal matters. On criminal matters, if you've been arrested, sometimes the weapons surrender hearing really happens at the time you first see the court. They might, right when you're arraigned, say, do you have any weapons? If you say no, there could be a form you fill out that says declaration of non-surrender, and that would mean that you are done with the weapons part at that point. Another thing that could happen is you bail out and you do have weapons, so they might we're going to give you 5 days to turn in your weapons. We're going to set a hearing 5 days from now to review your paperwork. Have you filed paperwork showing you turned in your weapons? Do we have the law enforcement signatures? Or have you filed paperwork saying you don't have any weapons? In those cases, oftentimes in criminal matters, oftentimes courts will cancel the weapon surrender review hearing if the paperwork's in order. Now, don't just skip it. Again, hopefully you have an attorney and the attorney can look into that. But if the attorney can help you get it canceled, you can miss less work. You can not have to go to court, which is stressful. It's just better for everybody all around. Let's say that the restriction is now lifted. The case is over. You no longer have a restriction. You think, I can just go in and get my weapons back, right? Well, it's not quite so simple. Law enforcement is very careful, and probably for good reason. Don't expect to get your weapons back overnight. You're going to need to go in. You're going to need to show the order that says you're no longer restricted. And then you're going to have to fill out some stuff at the police department, because they're going to need to do a brand new background check, right? They're going to see, well, can you still possess? Is there something we missed the first time? Has something changed? And so it can be weeks, maybe even longer during this COVID times before you get your weapons back. And so, I want you to have the right expectation that it may take a while, but they've got a duty to maintain the weapons. If something goes wrong, you can make claims against them and things like that. But I want to make sure that you have the right expectation going in. I think while we're not firearms experts, I'm sharing a lot of what we've experienced over doing this for 20 years. Another thing that could come up is, let's say that you don't possess any weapons. All your weapons have been maintained by your father, who's in another city. Well, you check with an attorney. Sometimes it could be possible to file a declaration of non-surrender as long as even though you own guns, but if you don't possess them and you can't get to them, someone else has them. Sometimes that might be possible, but each situation is unique, so you need to check with an attorney. Now, this isn't legal advice. I'm just letting you know educationally there are some ways around things. Additionally, I think the other thing I want to throw in here is if the restriction is maintained, and let's say you've got a 1-year order against you, and the police have your guns because you turned them in, you followed the law. Well, what can you do about it? Well, there are some exceptions about transfer of weapons to family members, and so you'd want to check with the police department and say, hey, is there a way that I could transfer the ownership of these weapons to a family member, because they're valuable and they could use them or they could sell them. I'm not allowed to touch them, I won't. But what is the procedure for doing that? And there are some exceptions in the law that could make that possible. Law changes again, so always check with an attorney. But the goal is to try to get you reunited with your property, because if you haven't used your weapons in a crime, you shouldn't lose them. But again, this is what the law is today. So I hope you found this useful for what to expect at a weapons surrender hearing. Again, the most serious ones I see are on the civil side versus the criminal. And I'm not talking about extreme risk protection orders. That's a different video. If you found it useful, please like and please subscribe. More people will get the information out there. And if you're facing this type of situation, we may be able to help. Feel free to give us a call. If this is within our wheelhouse of what we do, we'll usually offer to get involved. If we think it's too complicated that it takes someone who's only focused on firearms, we have several people could refer you to. But regardless, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.